Assets owned by a third party which are in possession of the CD, including subclause 1, 2, and 3. What does the subclause 3 say? It says all sums due to any workman or employee from the Provident Fund, Pension Fund, and the Gratuity Fund. So these funds will belong to the workman or employee which are kept with the CD, and CD is merely a custodian, and that means liquidator shall also be merely a custodian for the workmen or employees, and he shall not touch these funds and make them a part of the liquidation estate assets, and these funds shall not be used for recovery by the other stakeholders or the creditors while liquidating the assets of the company. Section 53 of the IBC is also known as waterfall mechanism. It deals with the distribution of assets. We have already discussed about the status of workmen and employees under this section and the ranking that has been given to them by the law. Section 155, estate of a bankrupt contains the provisions related to what all shall be included or what shall not be included in the estate of a bankrupt. So subsection 2 of section 155 provides that estate of a bankrupt shall not include the sums due to workmen or employees on account of Provident Pension Fund or Gratuity Fund. This is similar to section 36, subsection 4, subsection A, subclause 3, which we have just seen. It says any sums due to any workman or employee from these funds shall not form part of the liquidation estate. Similarly, these funds shall not form part of the estate of a bankrupt. Section 178 says, gives us the priority of payment. This is similar to section 53. It says, notwithstanding anything to the contrary contained in any law enacted by the Parliament or the state legislature for the timing in force, in the distribution of final dividend, the following debts shall be paid in priority to all other debts. Similar to section 53, it says, firstly, the costs and expenses incurred by the bankruptcy trustee for the bankruptcy process in full. Secondly, the workmen's dues for the period of 24 months preceding the bankruptcy commencement date and the debt owed to secured creditors, both of them again ranking equally. Third, wages and any unpaid dues owed to the employees other than workmen of the bankrupt for the period of 12 months preceding the bankruptcy commencement date. So this is absolutely similar to section 53. Continuing, fourthly, any amount due to the government or state authorities. Lastly, all other debts and dues owed by the bankrupt, including unsecured debts. In case the debts in any class specified in section 1 shall rank in order mentioned in that, but the debts shall rank equally amongst themselves and shall be paid in full unless the estate is insufficient to meet them, which is similar to subsection 2 of section 53. Then subsection 3 is where any creditor has given any indemnity or has made any payment of monies by virtue of which any asset of bankrupt has been recovered, protected, or preserved. The AA may make such order as it thinks just with respect to the distribution of such an asset with a view to giving that creditor an advantage over the others. Unsecured creditors shall rank equally amongst themselves unless contractually agreed to the contrary. Any surplus remaining after the payment shall be applied in paying interest on those debts in respect of period during which they have been outstanding. Interest payments shall rank equally irrespective of the nature of the debt. In case of partners, the partnership property shall be applicable in the first instance in payment of partnership debts, and the separate property of each partner shall be applicable in first instance of payment of his separate debts. So these are different from section 53. But the status of workmen and employees stands at the same ranking and same footing. Other provisions under IBC are given under the CIRP regulations. The proof of claims. Chapter 4, it gives regulation, under regulation 9, it is given how the claims shall be filed by the workmen and employees. A person claiming to be a workman or an employee of the corporate debtor shall submit a claim with proof to the IRP in person, by post, or by electronic means in Form D of the Schedule 1, provided that such person may submit supplementary documents or clarifications in support of the claim on his own or if required by the IRP before the constitution of the COC. It further says that where there are dues to numerous workmen or employees, an authorized representative may submit one claim with proof for all such dues on their behalf in Form E. The existence of dues to workmen or employees may be proved by them individually or collectively on the basis of records available within IU or other relevant documents, including a proof of employment, such as contract of employment for the period for which such workman or employee is claiming the dues, evidence of notice demanding payment of unpaid dues, any documentary or other proof that payment has not been made, or an order of a court or tribunal that has adjudicated upon the non-payment of dues. Chapter 5 provides Regulation 16, which contains provisions regarding constitution of COC if there are no financial creditors. It provides for a representative of workmen and employees in the said committee, where the CD has no financial debt or where all the financial creditors are related parties of the CD. The committee shall be set up in accordance with this Regulation 16. The committee formed under this regulation shall consist of members as 18 largest OCs by value, provided that if the number of OCs is less than 18, then the committee shall include all such OCs. B. One representative elected by all workmen and other than those workmen included under A. If the workmen have already been included under A, then the rest of the workmen shall provide one representative to be elected on the COC. One representative elected by all the employees other than those employees who have been included under subclause A, if any. So this gives and means they have to be there. So not only the 18 largest OCs in value, but also one representative from the workmen and one representative from the employees shall be constituting the COC. A member of the committee formed under this regulation shall have voting rights in proportion to the debt due to such creditor or debt represented by such representative as the case may be to the total debt. For the purpose of this regulation, total debt is the sum of amount of debt due to creditors listed in subregulation 2A. This is subregulation 2A. So this is the total debt. The amount of the aggregate debt due to workmen under subregulation 2B and 2C. A committee formed under this regulation and its members shall have the same rights, powers, duties and obligations as a committee comprising FCs and its members, as the case may be. So here the workmen and employees through their representatives are getting the same powers and duties and obligations as a normal COC having FCs shall be having. Chapter 10 gives Regulation 36, which talks about the provisions regarding information memorandum to be prepared and submitted by the RP. It includes a list to be of workmen and employees of the CD and the liabilities towards them. The IM shall provide, it shall highlight the key selling propositions and contain all relevant information that serves as a comprehensive document conveying significant information about the CD, including its operations, financial statements to the prospective resolution applicant, and shall contain the following details of the corporate debtor. Subsection HI provides the number of workers and employees and liabilities of the CD towards them. So the crystallized liability as on the insolvency commencement date has to be provided in the IM. Now, it is not labor code. Sorry, it has been wrongly written here. It should be benefits under the labor laws. Existing labor laws are not the labor code, and unified labor code, though it is ready, and I have included some provisions for those labor code also in my presentation, but that has not yet been implemented. And it is, I think it is on the verge of implementation because very recently in September 2022 also the central government has given direction to the states to make the rules on the balance labor code rules, which have not yet been drafted, and they are in the process of submitting those rules to the central government. At any point of time, this is expected to be implemented. So right now what we'll be studying in the upcoming slides shall be the labor laws only, which are in place as of now. So first of them is Payment of Gratuity Act, applicability of Act. Why understanding the labor laws or maybe the labor code is important for an IP? Because while the company is in going concern or while calculating the outstanding debts, claims, while verifying the claims at the insolvency commencement date, one has to know which laws were applicable to the company, which employees are forming part of the definition of employee under Gratuity Act, under Bonus Act, under Provident Fund and miscellaneous benefits, so that the correct calculation and the claims can be correlated, verified, and then admitted. So first of all, first we'll take up the Payment of Gratuity Act. Applicability. The Act provides for a scheme for the payment of gratuity to the employees engaged in factories, mines, oil field plantation, ports, railway company shops, or other establishments. The Act enforces the payment of gratuity, a reward for long service, as a statutory retirement benefit. Every employee, irrespective of his wages, is entitled to receive a gratuity if he has rendered continuous service of 5 years or more than 5 years. It is not paid to an employee gratuitously or merely as a matter of boon. It is paid for the services rendered by him to the employer. Payable to an employee on termination of his employment after he has rendered continuous service for not less than 5 years, on his superannuation, on his resignation, or on his death or disablement. The Working Journalist and Other Newspaper Employees and Miscellaneous Provisions Act provides for payment of gratuity after 3 years of continuous service. The payment of gratuity shall be forfeited to the extent of damage or loss caused by the employee to the property of the employer, or where the service of employee is terminated due to his misconduct. According to Section 2E, here employee has a different meaning. It means any person other than an apprentice employed on wages in any establishment, factory, mine, oil field, plantation, port, railway company, shop, to do any skilled or semi-skilled or unskilled manual, supervisory, technical or clerical work, whether the terms of such employment are expressed or implied, and whether or not such person is employed in a managerial or administrative capacity, but does not include any person who holds a post under the central government or state government, or is governed by any other act or by any rules providing for payment of gratuity. According to Section 2A, subsection 1, an employee shall be said to be in a continuous service for a period if he has, for that period, been in uninterrupted service, including service which may be interrupted on account of sickness, accident, etc., not being in absence in respect of which an order treating the absence as break in service has been passed, or a layoff, strike, or lockout of work, not due to any fault of employee. Even that interruption shall be included and will not be considered as a break, whether such uninterrupted or interrupted service was rendered before or after the commencement of the. Where an employee is not in continuous service within the meaning of clause 1 for a period of 1 year or 6 months, he shall be deemed to be in continuous service under the employer for the said period of 1 year if the employee during the period of 12 months preceding the date with reference to which calculation is to be made has actually worked under the employer for not less than 190 days in case of employee employed before below the ground in a mine, etc., or 240 days in any other case. So one has to know the provisions while calculating the gratuity for the employees who are retrenched or who have resigned or whose services are terminated with the insolvency commencement date or on the liquidation commencement date or during the CRP. If the RP doesn't want them to continue and the gratuity needs to be calculated, then one must go through the relevant provisions. For the purpose of clause 2, the number of days on which an employee has actually worked under an employer shall include the days on which he has been laid off under an agreement or as permitted by standing orders made under the Industrial Employment Standing Orders Act or under the Industrial Disputes Act or any law applicable to the establishment. He has been on leave with full wages earned in the previous year. He has been absent due to temporary disablement caused by accident. In case of a female, she has been on a maternity leave. Where an employee employed in a seasonal establishment is not in continuous service within the meaning of clause 1 for any period of 1 year or 6 months, he shall be deemed to be in continuous service under the employer for such period if he has actually worked for not less than 75% of the number of days on which the establishment was in operation. What rate shall be applied? For every completed year of service, a part thereof in excess of 6 months, the employer shall pay gratuity to an employee at the rate of 15 days wages based on the rate of wages last drawn by the employee concerned. So at the time of retirement or at the time of retrenchment, whatever the rate of wages was, 15 days wages shall be calculated, multiplied by the number of years of completed service, or and adding any year in which the more than 6 months has been employed. In the case of piece rated employee, daily wages shall be computed on the average of the total wages received by him for a period of 3 months preceding the termination of his employment, and for this purpose the wages paid for any overtime work shall not be taken into account. In case of an employee who is employed in a seasonal establishment and who is not so employed throughout the year, the employer shall pay the gratuity at the rate of 7 day wages for each season. In the case of a monthly rated employee, the 15 days wages shall be calculated by dividing the monthly rate of wages last drawn by him by 26 and multiplying the quotient by 15. The amount of gratuity payable to an employee shall not exceed 3,50,000 rupees in any case. Now, what is the responsibility of an employer? Every employer, other than the employer or an establishment belonging to or under control of the central government or state government, shall, subject to the provisions of subsection 2, obtain an insurance in the manner prescribed for his liability for payment towards a gratuity under this Act. The appropriate government may, subject to the conditions prescribed, exempt every employer who had already established an approved gratuity fund in respect of employees and who desires to continue such arrangement, and every employer employing 500 or more persons who establishes an approved gratuity fund in the manner prescribed. Where an employer fails to make any payment by way of premium to the insurance or by way of contribution to all approved gratuity fund, he shall be liable to pay such sums as have been provided under the Act. Now, next is the Employees Provident and Miscellaneous Provisions Act. An act to provide for the institution of provident funds, pension funds, and deposit linked insurance fund for the employees in the factories and other establishments. The applicability is all the factories and establishments in which 20 or more persons are. Schemes are there under this Act: Employees Provident Fund Scheme, Employees Pension Scheme, Employees Deposit Link Insurance Scheme. Any employee at the time of joining the employment and getting wages up to 6,500 he becomes a member automatically at the time of joining. An employee is eligible for membership of fund from the very first day of joining in a establishment on which this Act is applicable, and this applicability is having employees more than 20 in number. Employees' share is 12% of basic plus DA, and the employer's contribution is 12%, which is to be deposited at 8.33% to be deposited in pension fund, and the balance, that is 3.67, is to be deposited in provident fund along with the employee's share. There are administration charges, 1.1% of the total wages or salary disbursed by deposit to account number 2. Account number 2 is the provident fund account. Employees deposit linked insurance at the rate of 0.5% of the total wages or salary by deposit to account number 21, and administration of EDLI at the rate of 0.01% of wages or salary by deposit to account number 22. So these charges and the detailed illustrations are given under the Act. So if you need to calculate the charges and the amount of contribution, you will have to go through the Act in detail. What are the duties of employer? Employer has to furnish information about the ownership and names of responsible persons of the establishment, declaration and nomination, joining and leaving of service by members in the respective forms, Form 12A with monthly challans of deposit, Form 9 for details of employees, Form 3A or 6A at the end of financial year, any other information as may be required under para 76 of the respective scheme. Benefits, let's skip it for a while because we are looking at the employer's duties right now. Pension benefits are available to the member, available to the family. What is a scheme certificate? This certificate shows the service and is a proof wherein family details of the member are given. It is issued if the family member has not attained the age of 58 while leaving the establishment and he applies for this certificate. He can surrender this while joining another establishment and the service stated in the certificate is added with the service he is gaining from the new establishment. So these are important benefits one needs to give to the employees at the time of their joining or leaving respectively, and as an employer the IP will also have to ensure this. After attaining the age of 50 or above, a member can apply for pension by surrendering this scheme certificate. It could be a better choice than the withdrawal benefit that if a member dies holding a valid scheme certificate, his family will get pension. Withdrawal benefits, let's skip it for a while. Death benefits, I'm also skipping this. Now the Payment of Bonus Act. The Payment of Bonus Act provides for payment of bonus to the persons employed in certain establishments on the basis of profits or on the basis of production or productivity and for the matters connected therewith. It extends to whole of India and is applicable to every company and other establishments where 20 or more workmen are employed on any day during an accounting year. Every employee receiving a salary or wages up to rupees 10,000 per month and engaged in any kind of work, whether skilled or unskilled, managerial or supervisory, is entitled to bonus for every accounting year if he has worked for at least 30 working days in that year. Where an employee has not worked for all the working days in a year, the minimum bonus of 100 rupees, or as the case may be 60 rupees, if the bonus is higher than 8.33% of his salary or wage for the days he has worked, he shall be proportionately paid and the calculation shall be proportionately made. Employees of LIC, universities, etc., RBI, IFCI, UTI, social welfare institutions, they are not entitled to bonus under this act. How the working days shall be calculated in an accounting year. An employee shall be deemed to have worked in an establishment in any accounting year also on the days on which he has been laid off under an agreement. It is similar, this calculation is similar for the purpose of when we are calculating the gratuity, the number of days he has worked. So these provisions are quite similar. He has been laid off under an agreement or as permitted by the standing orders or under any other law applicable to the establishment. He has been on leave with salary. He has been absent due to temporary disablement caused by accident arising out of, in, or in the course of employment. The employee has been on maternity leave with salary or wages. Disqualification means an employee shall be disqualified from receiving bonus if he is dismissed from service for fraud or riotous or violent behavior while in the premises of the establishment, or theft, misappropriation, or sabotage of any property of the establishment. What is the minimum amount of bonus which an employer is required to pay even if he suffers losses during the accounting year or there is no allocable surplus of 8.33% of the amount of minimum bonus is 8.33% of the salary or wages during the accounting year, even if there is no surplus or profit. Even if the employer is having losses, he has to keep aside this balance. Rupees 100 in case of employees above 15 years of service and 60 in case of employees below 15 years of service with the employer at the beginning of the accounting year, whichever is higher. If in an accounting year the allocable surplus calculated after taking into account the amount set on or the amount set off exceeds the minimum bonus, the employer should pay bonus in proportion to the salary or wages earned by the employee in that accounting year, subject to a maximum of 20% of such salary or wages. Bonus should be paid in cash within 8 months from the close of accounting year or within 1 month from the date of enforcement of the award, or coming into operation of a settlement following an industrial dispute regarding payment of bonus. However, if there is sufficient cause, then extension may be applied for. The method of calculation of bonus is to calculate the gross profit in the manner specified in the first schedule in case of a banking company and in the second schedule of this act in case of any other company. Available surplus is equal to gross profit minus depreciation admissible under section 32 of Income Tax Act minus development allowance minus direct taxes minus sum specified in third schedule. And B, adding B to the gross profit. B is direct taxes in respect of gross profit for the immediately preceding accounting year minus are the direct taxes in respect of such goods such gross profit as reduced by the amount of bonus for the immediately preceding accounting year. Allocable surplus is 60% of the available surplus and 67% of the in case of the foreign companies. Then you have to make adjustment for set on or set off for calculating amount of bonus in respect of an accounting year. Allocable surplus is computed after considering the amount of set on and set off from the previous years as illustrated in the fourth schedule. So my idea of containing all this in the presentation and telling you all this is to comply the law while being an IP or the liquidator, because now this is being seen very seriously and it has been observed that the law is being complied with or not by the IP being in the capacity of an RP, IRP or a liquidator. So one must understand and find out which all laws are applicable to our company. If it is a going concern, then it is all the more important to find out which how many employees are there, which all labor laws are applicable, and what are the dues payable to them as on insolvency commencement date as well as during the CRP or the liquidation period. Duties of the employer: to calculate and pay the annual bonus as required under the Act, to submit an annual return of bonus paid to the employees during the year in respective form to the inspector within 30 days of expiry of the time limit specified for payment, to cooperate with the inspector, produce before him the register or record maintained and such other information as may be required by them, to get his account audited as per the directions of a labor court or tribunal or of any such other authority. It is seen in most of the cases where prior cases are pending and previous assessments are being made by the PF or bonus or whichever authority or the inspector. RPs are busy contesting that previous period liabilities are not applicable to us, previous period assessments we will not cooperate, we will not produce the relevant registers, documents, etc. We will not produce a record. But they in this process they forget that during the CRP they need to maintain the records or the registers, and in the eventuality the RP is under scanner from the same inspector. While contesting for the previous period uh, liabilities or omissions, please understand that the CRP period or liquidation period duties are to be duties of the employer are to be followed by IP. The rights of the employer: the right to forfeit bonus of an employee who has been dismissed for service from fraud, etc. This we have seen. Right to make permissible deductions from the bonus payable to an employee, such as festival or interim bonus paid, and financial loss caused by misconduct of that employee. Right to refer any disputes relating to application or interpretation of any provision of the Act to the labor court or labor tribunal. Rights of employees: right to claim bonus payable under the Act and to make an application to the government for the recovery of bonus due and unpaid within 1 year of its becoming due. Right to refer any dispute to the labor court or tribunal, or employees to whom payment of bonus act does not apply cannot raise a dispute regarding bonus under the Industrial Disputes Act. Right to seek clarification and obtain information on any item in the accounts of establishment. So here payment of bonus act gives 1 year for the employee to make a claim with the government, but in CRP or in liquidation they have respective periods for which they can claim their dues. That is 12 months from the 24 months from the date of liquidation commencement or from their retrenchment, and 12 months prior period of liquidation commencement, or in case of insolvency commencement date claims are crystallized, then those are to be dealt with by the RA in the resolution plan. Offenses and penalties, I'm not going through these. So what are the labor laws? We have seen why these labor laws, they have been established to ensure health, safety, welfare, social security, to deal with the industrial disputes, etc. But now we have, as I told you, we have shifted to the labor codes. It's on the verge of implementation only. On the recommendation of Second National Commission on Labor, the Ministry of Labor and Employment codified existing central labor laws. They are in numbers, and they have been codified and they have been merged to only 4 codes. One is code on wages, one is occupational health and safety, one is code on social security, and one is industrial relations code. Press release in March 22, which has provided an update on the progress, still does not talk about the effective date. As I told you, in September only there was a direction from central government to the states. Being a concurrent subject, the center and the state both have their duties to form these laws, but government is still waiting for comments and waiting for all the states to draft their rules under these 4 laws. So this is how the states are divided on the rules which are to be made. Which laws are combined, merged after the codification of all the centralization of all the labor laws? Code on Wages 2019, if and when implemented, shall subsume the Payment of Wages Act, Minimum Wages Act, Payment of Bonus Act, and Equal Remuneration Act. Code on Social Security shall subsume the Employees Compensation Act, Employees State Insurance Act, Employees Provident Funds, Miscellaneous Provisions Act, Employees Exchanges, Maternity Benefit Act, Payment of Gratuity, and Senior Worker Welfare Act. Occupational Safety, Health and Working Conditions Code shall subsume the Factories Act, Contract Labor Act, Mines Act, Dock Workers Act, Building and Other Construction Workers, Plantation Labor, Interstate Migrant Worker, Working Journalist and Other Newspaper Employees Act, Working Journalists, etc. So these also need our attention. Once these codes are issued, these are already there in the public domain. The rules are also there for the general public to have a look upon. So while calculating, right now the existing labor laws are applicable, but as soon as these are applicable, these shall be implemented. As soon as these are implemented, these shall be applicable with immediate effect on the companies going through CRP also. So the last being Industrial Relation Code, which shall subsume the Trade Unions Act, Industrial Employment Standing Orders Act, and the Industrial Disputes Act. So we can see the centralization of whole plethora of the laws which are existing in today's date. They shall be centralized into these 4 codes only. Let us see. I have only taken a few highlights of the labor code. What is the definition of employee under labor code? It means any person other than the apprentice employed on wages by an establishment to do any skilled, semi-skilled, unskilled, operational, supervisory, managerial, or so and so. And also includes a person declared to be an employee by the appropriate government, but does not include any member of armed forces of union. Worker. Worker means any person except an apprentice. So apprentice has been defined separately. Earlier, workman includes separate apprentice in today's date. Employed in an industry to do any manual, unskilled, skilled, technical, operational, clerical, or supervisory work for hire, and it includes the working journalists as defined under Clause F of Section 2 of Working Journalist and Other Newspaper Conditions of Service and Miscellaneous Provisions, and sales promotion employees as defined under Sale Promotion Employees Act. And for the purpose of any proceedings under this code in relation to industrial dispute includes any person who has been dismissed, so and so, so and so. So this is only a merger of definitions from different acts together. These people shall not be, but does not include any such person who is subject to Air Force Act, Army Act, or Navy Act, who is employed in police service, who is employed in managerial or administrative capacity, who is employed in a supervisory capacity, drawing a wage of exceeding 15,000 rupees. So the amount has been changed to 15,000. So shall we take a break here, because now it is we are entering into very important judgments under the IBC.
Ma'am, we can take a break for 5 minutes.
5 minutes only.
Yes, ma'am.
All right.
Ma'am, we can take a
Okay.
longer break also as per your convenience.
Okay. Let's meet at 310. Is that okay?
Okay.
10
Okay.
minutes past 3.
Yes,
All
ma'am.
right. Yeah. Thank you so much.
Okay. Thank you.
Part of the liquidation estate.
Yes.
And, a corporate debtors assets will contain these things because they will be in the name of either employees trust or a PF separate trust. Normally, it cannot be in the name of the company. What is your view on that?
Yes, they are not in the name of the company, but they belong to the employees. and the CD is a custodian of,
That's
and
okay,
later on
but
the IP. Yeah.
when they are
So
not part of the assets, where is the question of they becoming the part of liquidation estate?
see, liquidator, what does he do? Or the RA, in some cases, they have done it. They have considered it to be a part of the property available, the amount or asset available to the RA. And in some cases, liquidator has used this fund to, reimburse or repay the liabilities of the other stakeholders, primarily the other creditors, secured creditors. So this has been clarified by the Supreme Court in various judgments. We will go through them now, that why this was included as such, as an exclusion specifically under the code itself, because this amount, though it has been paid by the CD, but it belongs to the employees only, and they will only be paid out of this fund.
Even
Any
if you
liabilities.
consider the accounting norms also, it cannot be a part of the company's assets. So that's what I believe.
Yes. Yes, you understand it very correctly, sir. But some people initially they did not have this understanding, and many of them have made these mistakes. Even the RA tries to do that.
Okay, let us
Yeah.
go through these judgments.
Yeah. Any other questions or any other experiences you wish to share regarding the workmen's dues? If you have dealt with being IPs, you must have dealt with the situations. If you have calculated or calculated the liabilities as on the LCD or the ICD, any experiences?
Note, I just want to clarification from you regarding
No,
this.
no, no. I'm asking to all of the participants present over here.
Okay,
All of them are IPs. They might have come across a situation where they would need to calculate, or it is a going concern under CRP or liquidation, anywhere. The labor laws, whenever they are applicable, they might have calculated or appointed an HR person specifically for this purpose. No experiences?
only cases, madam, not experiences, because the PF department is so adamant.
Yeah.
They basically they want the previous records. If you ask them to file a claim,
Yeah.
they don't have any records, and they ask us to provide records for the last 8 years, 10 years.
So, what is the solution you see in such a situation?
That is an experience. See, what happens is in many of the cases, I have seen in an infrastructure company, people handling projects at 10 to 11 sites.
Mm-hmm.
There are some employees who work for 1 year, 2 years, and leave. Many of the like
Madam, this gratuity is maximum 350 or it has been increased?
so
What? Sir, this is
This
350 at present.
at present
The
350
maximum
maximum.
amount, yes.
Okay, and this all the labor codes which you have enlightened us with, whether they will replace the Industrial Disputes Act?
Yes. The
Industrial
Industrial
Disputes Act.
Relations Act will include the Industrial Disputes Act. All the provisions relating to Industrial Disputes Act will be covered under Industrial Relation Code now.
Okay, okay.
Sorry,
So
sir.
when
Srinivas, sir, was saying something. Yeah. Let him
absence,
explain. Yeah.
in the absence of the promoters who are least interested in the company and who are living in abroad,
Mm-hmm.
finding the records and who have worked 4 years before or 6 years before is becoming very difficult. And
Yes.
when you ask them to file a claim, they ask for these records.
Yes.
One or two employees, they may file a case in the PF with the PF department. Then they issue summons to the RP.
Yeah.
So
So,
getting these records of the earlier employees is becoming a big task actually. Whatever available records we are providing, but in some cases we may not be able to get beyond 3-4 years. With so many sites at place, and when the salaries are not paid, all the HR department employees, all of them have left the organization. So there is no
yeah.
one to provide the data.
Yeah. So what have you done in such situation? You must have
Whatever
asked,
is the
sought
available
directions
information,
from an.
no. Whatever is the available information we have provided, and ask them whether they must be receiving the annual returns or half-yearly returns, PF department. They must be having data. Suppose if someone is claiming a PF due or something like that, they must have a record with them also.
Yeah.
So that they are not providing. Instead, they are asking the RP. They are making the RP responsible for all the information.
Yes. And in that hustle bustle, what happens is RP is busy replying to their,
Correct, correct.
unnecessary notices of belonging to previous period defaults, if etc. And in that period, during the compliances of relating to the CRP period get missed. No,
Correct.
that is the casualty.
If the number of employees is more running into hundreds and thousands, then it
Yeah.
becomes a very big task.
Yes.
Collating all these records and submitting
So
the calculating
the
PF dues.
at the IRP stage itself, one must assess the situation of the company
The case
where it is
is
lying.
many of the employees, if the organization is defunct or not running for the last 1 year, 2 years, then in the this is a case of an infrastructure company having locations in different states. So their employees are not aware of the CARP. How can they file claim
Yes.
for the
Even the PF department is sometimes not aware.
yeah. At least PF department we can write a letter or send an email one or two times. But many of the employees are not aware of the initiation of CRP. They file claims at very belated claims, almost at the verge of closing of the resolution plan and like that.
Yeah.
But the NCLTs are very flexible and lenient towards employees and asking the
Yes.
RP to admit the claims even at a very belated stage.
Yes.
Then the calculation, again the calculation and redistribution of all these things is a very big task.
Actually, yes. Yes. Sunil ji, you were saying something?
I have inquired some questions. That is okay now.
Okay. Okay. Anyone else having any questions or any experiences to share here? Because this subject touches us all.
What's the difference of this 20 relevance of this 24-month period during CRP and during liquidation?
See, when it was being codified, that time it was understood that the process of CRP shall not take more than 6 to 9 months, right? And if liquidation is announced, that will also the liquidation commencement date will effectively will not be more than 12 to 24 months. Initially, liquidation period was 2 years, so it should not have been more than 24 months when a person has not been paid his dues. So in that context, the lower level workmen was given a period of 24 months and the employees were given a period of 12 months from the date when, but it was never assumed that previous 6 7 months salaries have already not been paid on the ICD. Thereafter, the CRP period is processing is being continued for more than 1 year or so. Then the liquidation process itself taking its own time. So the intervention of the legislation is required at this stage because most of the employees and the workmen are the worst hit by these processes and the delays. The OCs, including the workmen, including the employees and the government dues, they are the worst hit. They are not getting their dues. What to say, legitimate dues. They are not getting their dues
You mean
because
to
of
say
the
that
delays.
during liquidation it can be restricted to 24 months, and
Yes, it
if
has to
it
be.
is a resolution plan, it can be beyond 24 months.
Yes, but the amount to be paid is not mandatory, and the RA or the maybe if we are talking about the liquidation, the realization from assets may not be sufficient enough. So it has to be restricted to 24 months of dues
No.
only.
Suppose if any resolution plan comes and it is more than the liquidation value, in that case.
Yeah, if they are paying, then the entire dues will be paid, no? They can pay more than liquidation value to the employees or the government authorities.
It may not be sufficient to pay the not to pay the entire dues, but if it is more than 24 months, can that also be taken into account, or is it a mandatory one, or how?
No. That is not minimum. That is not maximum. 24 months is the minimum. And we are talking, you are merging two different things. 24 months is under the liquidation proceeds, distribution of liquidation proceeds. And RA can pay any sums due which have been admitted at the CRP commencement date. So if at the CRP commencement date 6 months salary was due and the liabilities thereon, then he can propose to pay the entire sums due. And the liquidation proceeds is something different we are talking about. 24 months is there in under section 53.
What is EDLI, ma'am?
Employee, what was it? Deposit linked insurance.
Okay.
Yeah. Okay. Let's go back to the presentation. Visible?
Yes, ma'am, visible.
Yes, ma'am.
So, so first one is the Asset Reconstruction Company India Limited versus Precision Fasteners Limited. In this case, the NCLAT held that in alignment with the provisions of EPF Act, under section 36(4)(a) subsection 3, the code has gone ahead saying that the dues in respect of the Provident Fund, Pension Fund, Gratuity Fund, they shall not be treated as part of the liquidation estate. As long as such dues are not treated as part of liquidation estate, the provisions of IBC will not be applicable for realization of such dues from the assets of the CD. So, intriguing aspect lying in this scenario is that though it is a due payable by the CD, as to the Provident Fund or Pension Fund or Gratuity Fund dues are considered, the code has treated them as an asset of the workman lying with the CD. So these shall not be used for recovering and for realization and for distribution of proceeds to the other stakeholders. The overriding effect of section 238 of this code will not have any bearing over the assets of the workman lying in the possession of the CD, because the asset is not considered as a part of the liquidation estate. Moreover, to apply section 238 over any other law for the time being in force, the other law must be inconsistent with the provisions of this code. Since section 336 subsection 4 subsection A subsection 3 has excluded the PF dues of the workmen from the liquidation estate assets, treating it as an asset of the workmen lying with the CD, section 53 is not applicable to say that these dues fall within ambit of the liquidation estate. Therefore, the argument of inconsistency raised by the liquidator counsel had no merit and the same was rejected. Provident fund dues, pension dues, and gratuity fund dues are not treated as a part of liquidation estate and would not therefore be recovered by section 53 of the code, which provides for waterfall mechanism. In the case of Alchemist Asset Reconstruction Company Limited versus Mozabear India Limited, the ratio which has been set out in this judgment was the employee and workman dues are not part of liquidation estate. They are to be paid on priority. The dues of workmen and employees towards Provident Fund, Pension Fund, and Gratuity Fund are considered the assets of workmen or employees which are lying with the CD. These dues are therefore to be paid to the workmen or employees on priority without reference to or without waiting for distribution of liquidation assets as per the waterfall mechanism stipulated by the code. So one does not need to wait for section 53 distribution of assets, and these can be distributed even prior to that. Can anyone tell me whether the CRP or the liquidation costs shall be deducted from the these funds prior to distributing to the employees or workmen?
Please repeat the question, ma'am.
Whether the CRP cost and the liquidator's fees or the liquidation cost shall be deducted proportionately from these funds prior to distributing them to the workmen or employees?
No, it is not applicable to them, na?
Yes. If
No.
They are not
anyone,
part of the this CIRP.
yes, they are not part of the liquidation proceeds. They cannot be touched by any other costs or any other deductions. They will purely belong to the workmen or employees. The NCLAT observed The NCLAT observed that the comparison between Section 326 of the Companies Act and Section 53 of the Code would be misplaced, as there is a stark difference between distribution of assets under the Code and the preference or priority of workmen's dues as mentioned under the Companies Act. The NCLAT also noticed that the workmen's dues covered by Section 53 1B subclause 1 of the Code are only for a period of 24 months preceding the liquidation commencement date, while the workmen's dues falling under Section 326 of CA are not confined to any such specified period. Furthermore, the provisions of Code override the provisions of Companies Act. The NCLAT accordingly held in this case that the definition of liquidation estate under Section 36 specifically excludes the dues to the workmen and employees on account of Provident Fund, Pension Fund, and Gratuity Fund. These dues, therefore, do not form part of the liquidation estate or liquidation assets of the CD and are rather treated as assets of the workmen or employees lying with the CD. LAT further observed that since the liquidation estate does not include the sums due to workmen and employees toward PF, and gratuity fund, the question of distribution of these funds as per Section 53 under the Code does not arise. On the aforesaid findings, the NCLAT declined to interfere with the findings of the order of AA. Resultantly, the dues to any workman or employee on account of provident fund, pension, or gratuity are to be paid on priority and without preference to or waiting for the distribution of assets as per the waterfall mechanism stipulated by the code.
Slide move नहीं हो रहा शायद.
Okay. Is this okay? No, it is not moving.
Yes.
Okay. In the matter of Mr. B. Parmeshwara Udpa, who is the RP of Mrs. Eason Railroad Limited versus Assistant PF Commissioner. In this case, the AA, by its order dated 20th April 21, disposed of an application with a direction to the appellant to make adequate provisions in relation to the amount stated in order of attachment as due towards PF dues and subject to making adequate provisions to their satisfaction before respondents can remove the orders of attachment of the bank accounts of CD. So can you see what AA has done in this? So the question with the NCLAT was whether an attachment on bank account of CD imposed before initiation of CRP can continue during moratorium under Section 14 of the Code. NCLAT held that attachment of any bank account of CD by EPFO cannot be continued when moratorium is declared under IBC and proceedings are required to be kept in abeyance till lifting of moratorium. Liberty can, however, be given to the respondent to continue or initiate the proceedings against the CD after the disposal of the proceedings and lifting of the moratorium and completion of the corporate insolvency resolution process. Next question was whether RP is duty bound to make adequate provisions for Provident Fund even though the CD did not have separate PF account. NCLAT held that there is a difference between distribution of assets and preference or priority of the dues as mentioned under Section 53 of IBC and Section 326 of the Companies Act. It has also been noticed that Section 53, which relates to distribution of assets, workmen's dues, is confined to a period of 24 months preceding the liquidation commencement date. While applying Section 53 of the IBC, Section 326 is relevant for the limited purpose of understanding workmen's dues, which can be more than Provident Fund, Pension Fund, and Gratuity Fund kept aside and protected under Section 36 4A3. On the other hand, the workmen's dues, as mentioned in Section 326 1A, is not confined to a period like 24 months preceding the liquidation commencement date, and therefore the appellant, for the purpose of determining the workmen's dues, as mentioned in Section 53, cannot derive any advantage of Explanation 4 of Section 326 of the Companies Act. So, while calculating the workmen's dues, the entire workmen's dues shall be calculated as defined under Section 3, the explanation of Section 326 of the Companies Act. But while setting aside the funds for the purpose of calculating the liquidation estate under Section 36 of the IBC, only 3 funds are to be kept aside. So that is the difference the NCLAT had carried out. As the provisions of IBC have overriding effect in case of inconsistency in any other law for the time being in force, we hold that Section 53(1)(b, read with Section 36(4), will have the overriding effect on Section 326(1)(a), including the explanation thereof mentioned below that section. Once the liquidation estate or the assets of the CD under Section 36(1), read with Section 36(3), do not include all the sums due to any workmen or employees from the Provident Fund or Pension or Gratuity Fund for the purpose of distribution, the Provident Fund, Pension and Gratuity Fund cannot be included. The AA, having come to such a finding that the aforesaid funds do not come within the meaning of liquidation estate for the purpose of distribution, we find no ground to interfere with the said order. Thus, it is a settled position of law that the PF, pension and the gratuity fund do not come within the purview of liquidation estate for the purpose of distribution of assets. Based on this, the only inference which can be drawn is that PF, gratuity and provident fund cannot be utilized, attached or distributed by the liquidator to satisfy the claim of other creditors. Section 36 subsection 2 of the IBC provides that the liquidator shall hold the liquidation estate in fiduciary for the benefit of all the creditors. The liquidator has no domain to deal with any other property of the CD which is not the part of the liquidation estate. Thus, in a case where no fund is created by a company in violation of the statutory provisions of Section 4 of the Payment of Gratuity Act, then in that situation also the liquidator cannot be directed to make the payment of gratuity to the employees because the liquidator has no domain to deal with the properties of the CD which are not part of liquidation estate. So today he cannot create a fresh fund for those. Therefore, the appellate tribunal is of the considered opinion that the AA erred in directing the liquidator to make a provision for payment of gratuity to workers as per their entitlement. Thus, appeal was allowed in this case, and the direction to liquidator to make provision for payment of gratuity without there being a separate fund in this regard was set aside. Next issue which was dealt with by this judgment was whether the AA can direct RP to make provisions for PF funds without receiving claims for the same by the concerned authorities. NCLAT held that the respondents had not filed their claims within the prescribed time and the RP and they seek to reinforce their claims merely on the basis of orders of attachment passed much prior to the period of commencement of CRP. According to IBBI CRP regulations, Regulation 6 requires the RP to make a public announcement within 3 days of his appointment and ask for claims within 14 days of such announcement. Regulation 7 provides for claims by the OC and 8 provides for claims by the FC. 9 provides for claims for the workman and employee, etc. Further, in terms of Regulation 13, the RP is mandated to verify the claim and subsequently determine the amount of claim as per Regulation 14. It is therefore necessary that any person having claim over the CD has to prefer a claim as stipulated in such regulations. The tribunal does not agree with the AA, who gave such directions to the RP, to admit the claim of PF without receiving any claims from the concerned authority, only on the basis of the orders of attachment. In the matter of EPFO versus Vandana Garg and others in a company appeal, the NCLT approved the resolution plan, which waived off a major portion of Provident Fund dues owed by the CD. The appellant then filed an appeal before the NCLAT. The said appeal was dismissed by the Honorable NCLAT. The relevant para is: once a resolution plan is duly approved by the AA under subsection 1 of section 31, the claims as provided in the resolution plan shall stand frozen and will be binding on the CD, its employees, members, creditors, including the government and the local authorities, guarantors, or all the other stakeholders. Therefore, on the date of approval of the plan by the adjudicating authority, all such claims which are not a part of resolution plans shall stand extinguished, and no person will be entitled to initiate or continue any proceedings in respect to a claim which is not part of resolution plan. The 2019 amendment to section 31 of IBC is clarificatory and declaratory in nature and will be effective from the date on which IBC had come into effect. Consequently, all the dues, including the statutory dues owed to central government or state government or any local authority, if not forming part of a resolution plan, they shall stand extinguished, and no proceedings in respect of such dues for any period prior to the date on which the adjudicating authority grants its approval under section 31 could be continued thereafter. Based on the above, the law laid down by Honorable Supreme Court, it is clear that after approval of the resolution plan under section 31, the claims as provided in the resolution plan shall stand frozen and will be binding on the CD, its employees, members, creditors, government, local authority, guarantors, etc. On the approval of the plan by the AA, all such claims that are not part of the plan shall stand extinguished, and no person will be entitled to initiate continuing any proceedings regarding a claim that is not a part of the plan. The appellant's claim about Provident Fund dues amounting to rupees 1.95 crore, which was earlier raised at the time of initiation of CRP and was later admitted, that stood frozen and will be binding on all the stakeholders, including the central government. After approval of the resolution plan by the adjudicating authority, all such claims that are not part of the resolution plan shall stand extinguished. And this is the language taken from the judgment itself. So it is, coming again and again. By the time you reach to the end of the judgment, you learn by heart such sentences. No person is entitled to initiate or continue any proceeding regarding a claim that is not a part of the resolution plan. In such circumstances, the appeal deserved to be dismissed. In the matter of JK Jute Mill Mazdoor Morcha versus Jugilal Kamalpat Jute Mills Limited. Herein, a very important ratio was established. The SC upheld the insolvency application filed under Section 9 of the Code by a registered trade union, considering it to be an operational creditor for the purpose of the Code. The NCLT, while adjudicating the application filed by a trade union on behalf of nearly 3,000 workers of a debtor, had held that the trade union was not covered as an OC and had dismissed the insolvency application filed by them. In the appellate proceedings, the NCLAT also dismissed the trade union's application by stating that each worker could file an individual application before the NCLT. The Supreme Court, after studying various provisions of the Trade Unions Act 1926, observed that a trade union, being an entity established under the provisions of the Act, would fall under the definition of a person under Section 3, subsection 23 of the Code. So, who is a person? Let's go through the facts of the matter. The appellate trade union had issued a demand notice under Section 8 of the IBC on behalf of a large number of workers for their outstanding dues. The NCLT dismissed the petition filed by the trade union, stating that a trade union is not an operational creditor. The NCLAT also upheld the same, stating that each worker may file an individual application before the NCLT. So the issue involved was whether a trade union consider being a part of whether a trade union be considered being a part of IBC. Can it be an OC? Now let's go through the definition of the OC. Definition of operational creditor under section 5 subsection 21 of the IBC refers to a person. Now the person's definition is also given under section 3 subsection 23 of the IBC, which includes an entity established under a statute. So person includes an entity and OC is any person. Since a trade union is an entity established under Trade Unions Act, it would fall within the definition of person. The court also took the reference of Sanjay Sadanand Warrior versus Power Horse India Private Limited, wherein it was held that a trade union can file a winding up petition for outstanding wages of the workmen. What was the obiter dicta in this? Section 5 subsection 21 of the Insolvency and Bankruptcy Code states that the operational creditor means any person to whom an operational debt is owed and includes any person to whom such debt has been legally assigned or transferred and is owed an operational debt. The case was reverted back to the NCLAT, who shall decide the appeal on merits. The appeal was allowed accordingly. So what was the conclusion out of this judgment? In the above mentioned case, there was an issue that a trade union could be said to be an OC for the purpose of IBC. The court held that on the basis of section 3 subsection 23 of the code and referring some precedents, since a trade union is an entity established under Trade Unions Act, it would fall within the definition of a person under the IBC, and trade union can file a petition for outstanding wages of workmen. To state that for each workman, let there be a separate cause of action, a separate claim, and a separate date of default. This would ignore the fact that a joint petition could be filed under Rule 6 read with Rule 5 of Insolvency and Bankruptcy Application to AA Rules, with authority from several workmen to one of them to file the petition for all. So, considering that a joint petition is allowed, each worker need not file a separate application in this case. In the judgment dated this in the matter of Assam Tea Employees Provident Fund Organization versus Mr. Madhur Agarwal and other. What had happened was the AA wide order dated 21st January 20 initiated CRP against the CD. The Assam Tea Employees Provident Fund Organization submitted its claim for an amount of 2 CR, being the default on the part of CD to deposit its PF contribution. PF administrative cost, interest on delay in deposit of the PF, interest on delay in deposit of the deposit linked insurance dues, and PF contribution due, and payment for the period commencing from 28th March 2019 to 26 March 2019. So all this combined together reached to 2.1 CR. The resolution plan professional admitted the entire claim. Resolution plan came to be approved by AA wide order dated 3rd January 22. In the plan, the appellant was proposed. Who is the appellant here? The Assam Tea Employees Provident Fund Organization. They were proposed an amount of only 1 CR, and RP made a part payment of 64 lakhs. Aggrieved by the said order, an appeal was filed, wherein the NCLAT held that it first referred to its judgment in the case of Regional PF Commissioner versus Ashish Chaucharia, resolution professional for Jet Airways, wherein it was observed that the PF dues are not subject to distribution under Section 53, and further directed the successful resolution applicant to make payment of the admitted claim of the PF Commissioner towards Provident Fund dues to save the plan from invalidity under Section 30. Relying on its aforementioned decision, NCLAT held that the PF dues are not the assets of the city and they have to be paid in full, and the appellant was clearly entitled for payment of full PF dues, that in an amount of 2.1 CR. NCLAT issued a direction to the successful resolution applicant to make the payment of balance amount of PF to the appellant to save the resolution plan for becoming invalid. Regional PF Commissioner versus Ashish Chauria, resolution professional for Jet Airways, the one we have just referred. What happened in this? All the appeals were filed against the same order dated 22nd June passed by the NCLT Mumbai, which approved the resolution plan submitted by Jalan Fristek Consortium with respect to the CD, Jet Airways. First 5 appeals had been filed by the workmen and employees, and the last 3 appeals were filed by the OCs of the Jet Airways. All the appellants were aggrieved by the order of adjudicating authority, which had approved the resolution plans. Questions were whether the workmen and employees are entitled to receive the payment of provident fund, gratuity, and other retirement benefits in full since they are not part of liquidation estate under section so and so. Whether the workmen and employees are entitled to receive their dues from the corporate debtor as per the provisions of the code, that is the minimum liquidation value envisaged under section 30 subsection 2b for by referring to the waterfall mechanism. Any idea? Any answers to this? If we are not sleeping?
No, madam,
Yeah.
they are entitled to receive the payment of PF and gratuity.
Yes. Anyone else?
But
Second question.
But the only thing is, how can a successful resolution applicant who has already earmarked and finalized his plan can be forced to pay an additional amount in the, to take the example of Jet Airways case, it is almost 200 crores extra. Then the plan itself becomes unviable.
First question is yes, second question is no, ma'am.
Okay. Let's see what NCLAT held in this case. A great emphasis was laid down by the Learned Counsel for Appellant for their payment, for their entitlement for payment of full amounts of provident fund, etc. Section 36 subsection 4 provides that assets shall not be included under the liquidation estate, and all sums due to any workman or employee from PF, etc. The submission of the appellant was that when the sums due to the workmen from PF, etc. are excluded from the liquidation estate, the sums due to any workman towards such funds should be paid in full, and waterfall mechanism provided under section 53 should not be made applicable for computing such claims of the workmen and employees. Thus, the sums due to any workman from the above funds are excluded from the liquidation estate. Legislative intent is clear here that any sums due to any workman from the aforesaid funds are excluded and cannot be used for recovery in the liquidation. The object is that sums due to any workman or employee from the aforesaid funds should not be used for recovery in liquidation for dues of the other creditors, since these are exclusive to the workmen and employees. NCLAT held that we find ourselves bound to follow the 3-member bench judgment in Tourism Finance Corporation of India versus Rainbow Papers. We will also discuss this, where direction was issued to the successful resolution applicant to release full provident fund and interest thereof in terms of EPF and Miscellaneous Provision Act 1952, which judgment has also received approval by the Supreme Court. They have also considered section 326 and 327 of the Companies Act, which are not applicable in the event of liquidation under IBC as per subsection 7 added under section 327 by schedule 11 of the IBC. Section 53 refers to workmen's due, and by explanation appended to the same, the term workmen's due shall have the same meaning as assigned to it under section 326. But beyond that, we need not consider section 326 and 327 while undergoing IBC. Thus, for the computation of the workmen's due, the definition under section 326 has to be resorted to. The workmen's dues for the period of 24 months, including salary, allowances, and other claims to which the workman is entitled. For computation of the workman due, which is to be paid by the CD in the event of liquidation under section 53, workmen's dues are ranked equally with the secured creditors. In view of the aforesaid discussion, we arrive at the following conclusions. This is part of the judgment itself. The workmen and employees are entitled for payment of full amount of PF and gratuity till the date of commencement of insolvency, which amount has to be paid by the successful resolution applicant. consequent to the approval of resolution plan, in addition to the 24 months workman's dues as a workman is entitled to under section 53 of the code. It is made clear that in addition to part amount of provident fund and gratuity as proposed in the plan to the workman, SRA is obliged to make payment of balance unpaid amount of PF and gratuity to the workmen and employees. The workmen and employees are entitled to receive the amount of PF and gratuity in full, says they are not part of liquidation estate. The workmen are entitled to receive their dues from CD for a period of 24 months as per the provision of section 53, at least to minimum liquidation value, at least up to the minimum liquidation value envisaged under section 32 be read with 53. So this was the final verdict in this. There was also that might come under another judgment in this judgment itself in the matter of EPFO versus Vikas WSP Limited. Under section 32E, in order to be legitimate, the resolution plan cannot contravene any of the provisions of any law in force. So this is very tricky. While you must have come across this interesting question, which will revolve you around the plan so many times. If you have come across while doing a due diligence of a plan, can you share some of your experiences while doing a due diligence? What all do you check to check whether the plan it does not contravene any provision of any law? Have you carried out due diligence of any resolution plans? Must have. The resolution professional has to make sure that the plan does not contravene any provision of any law. While carrying out the due diligence of a resolution plan, have you seen the plan from the angle of the labor laws also? No answers. No one has carried out any
Labor
due
laws have
diligence.
been taken the back seat most of the times.
Yeah, yeah. Anyone else who has seen the labor laws also? Whether they were applicable to the CD, that RP must be aware. So whether the RA has taken care of those laws under the plan or not. Okay, the RP has not, but the NCLT has. So in the present context, it was incumbent on the RP as well as the RA to ensure that section 17B of EPF and MP Act, Miscellaneous Employee Provident Fund and Miscellaneous Provisions Act 1952 were complied with. Section 17B lays down that in case a transfer of establishment, the person to whom the establishment is transferred is also liable to pay the contribution and other sums due from the employer under any provision of Employees Provident Fund and Miscellaneous Provisions Act 1952. Therefore, the NCLT had directed the successful resolution applicant to make necessary payments under the provisions of EPF and MP Act after the approval of the plan. So here it is important for the RP also to check whether the compliance has been made with all the applicable laws to the company. The company may be specific, maybe having specific laws which are applicable to its business. So under section 32E, before assigning your statement, the assurance of SRA is there. I know all the plans have this assurance that the plan has not contravened any of the provisions of any law, but the RP has also to check whether the applicable laws have been complied with, or an assurance has been given that they will be applied with, even if it involves any cost. SBI versus Mauzaveya Karamchari Union and another. You must be aware about this judgment, right? The AA allowed the application holding that the Provident Fund, Pension Fund dues and gratuity fund dues cannot be a part of 53. NCLT directed that these funds do not come within the meaning of liquidation estate. It is relating to liquidation proceeding in which, relying on section 36, the AA had directed the liquidator to make the payment of PF, etc. On the basis of judgment of this tribunal in SBI's case was the code will have overriding effect, and the section 53 and 36 will have overriding effect on the sections 326, including the explanation given thereunder. Okay, I have only included the judgment portion here. Okay, all right. So this was having the same ratios which we have discussed already. This case was having the same ratio, but this was one of the first cases where the employees' dues were given importance. So this was initially for 2-3 years we have been following this case so much. Mr. Savan Godiwala, the liquidator of Lanco Infratech Limited versus Apala Sivakumar. What happened in this was the AA had directed the liquidator to pay gratuity to the employees. An appeal was filed in NCLAT which had been allowed. Against the above judgment, appeal was filed in Supreme Court and judgment is still under scrutiny by the Honorable Supreme Court. So let's leave this. Sikandar Singh Jamuwal versus Vinay Talwar and others. Here, an appeal was filed by ex-employee of respondent, that is the CD, challenging the order dated so-and-so passed by AA, which has approved the resolution plan. The grievance of the employee was that they have not been made the full payment of provident fund due to the CD. Other grounds for challenge were also raised. NCLAT, while considering the appeal, considered the provisions of Section 36 and 53. The tribunal placed reliance on the judgment of Tourism Finance Corporation versus Rainbow Papers and issued the following directions. We direct the respondent number 2, that is the SRA, to release full payment of full Provident Fund dues in terms of provisions of EPF and Miscellaneous Provident Fund Act 1952 immediately by releasing the balance amount of 1 CR minus what has already been considered in the resolution plans, that was up to 78 lakhs. So the order dated 2nd April, which approved the resolution plan, stood modified to this extent. Against the above judgment of this tribunal, a civil appeal was filed before the Honorable Supreme Court, which has been dismissed on 23rd September. So this has been concluded that SRAs all across are being directed to pay the full dues of employees' provident funds and gratuity wherever applicable. In Sunil Kumar Jain versus Sundaresh Bhatt, if anyone has come across this case, because this is such a wonderful case, they have explained so many questions of law, so many questions here are replied, taken up in this case, and they have been beautifully answered. Let us go through it one by one. The Supreme Court said that they have had an occasion to consider a case where an appeal by the workmen of Messrs. AVG Shipyard Limited, Mumbai, was dismissed by NCLAT. An application was filed by the workmen from claim of salary for the period involving CRP and the prior period, which was rejected. The Honorable Supreme Court had directed that the share of workmen's dues shall be kept aside outside the liquidation process, and the concerned workmen or employees shall have to be paid the same out of such provident fund, gratuity fund, and pension fund, if any available. If any provident fund, gratuity fund, and pension fund is available with the CT, the share of employees and workmen has to be paid from such funds, the said fund, which has to be kept out of the liquidation process. That is what the SC has told. The learned counsel for respondent relied on the words "if any available" occurring in the direction. The above words cannot be read to mean that the workmen and employees are not entitled for the funds if they are not available with the liquidator. If the claim of workmen and employees regarding payment of provident fund, gratuity fund, and pension fund can be satisfied from the fund maintained by the CD, that has to be kept out of the liquidation and cannot be utilized for distribution amongst other stakeholders. The workmen and employees are entitled for payment of full amount of provident and gratuity funds till the date of commencement of insolvency, which amounts is to be paid by the SRA consequent to the approval of plan, in addition to the 24 months workmen dues as the workmen are entitled under section 53(1). It is made clear that in addition to part amount of provident fund and gratuity as proposed in the plan to the workmen, SRA is obliged to make payment of the balance unpaid amount of provident fund and gratuity to workmen and employees. The PF etc. maintained by the CD have to be utilized fully for the payment of provident, pension, and gratuity funds of the workmen and employees, and thus these assets cannot be included in the IM as the assets of the CD while inviting the plans. When no PF, gratuity, etc. is maintained by the CD, such claims which have been filed before the resolution professional and admitted by him have to be satisfied as per the provisions of the code and as per section 30 subsection 2 read with 53(1). Present is not a case where RP has in IM entered the PF, gratuity or other funds or retirement benefits maintained by the CD so as to be part of resolution process. In admitted claim of workmen provident fund gratuity and leave encashment was included and payment proposed in the plan partly satisfied above dues. The workmen are entitled to full payment of provident fund and gratuity, and hence the balance of the above dues are to be paid by the successful resolution applicant to satisfy statutory obligations. Non-payment of full provident fund and gratuity shall lead to the violation of section 30 subsection 2e, which says that plan should not contravene any provisions of laws which are applicable to the CD. Hence, to save the plan, the above payments have to be made. The employees have not been paid anything in the plan towards provident fund which became due till ICD. The employees are entitled to be paid provident fund amount as admitted by the RP till insolvency commencement date. Similarly, the workmen whose gratuity amount became due before ICD are also entitled to receive the same after adjusting the part amount of gratuity which has been stipulated to be paid in the plan. Employees who became entitled to gratuity before insolvency commencement date are also entitled to receive the same since that liability is existing as on ICD. At this juncture, we may clarify that those workmen and employees who were demerged from CD and have not been treated to be terminated were not entitled for any gratuity or leave encashment. So, gratuity and leave encashment are only payable at the time of your retrenchment or termination of services or the retirement. Whether the claim of Regional Provident Fund Commissioner verified to the extent of 24 CR arising out of an order dated so and so passed under Section 14B of Employee Provident Fund and Miscellaneous Provisions Act can be treated as a secured debt and the appellant was entitled to receive the amount as secured creditors. The priority for payment of debts under Section 11 of this 1952 Act has to be looked into in view of the mechanism which is specifically provided under Section 53 of the Code. We have already dealt with the provision of Section 36 of the Code and held that provident funds are not subject to distribution. The issue is fully covered by the 3-member bench judgment of this tribunal in Tourism Finance Corporation versus Rainbow Papers. In view of the foregoing discussion, we hold that provident fund dues were entitled to be paid in full. In view of the judgment of Supreme Court in Maharashtra State Cooperative Bank Limited versus Assistant Provisional Provident Fund Commissioner and others, the claim of appellant was to be satisfied in full. Otherwise, breach of provision of Section 32 subsection E would have occurred. We are inclined to issue direction to the SRA to make payment of the admitted claim of appellants toward provident fund dues to save the plan from being invalid. The liquidation value of the workmen, as has been referred to in Form H, preferred by the resolution professional, is rupees 113 crores, and workmen were entitled to receive at least 113 crores as per the section 32B read with 53(1)B of the code, because they were entitled to receive the liquidation value. That was the minimum. Learned Counsel for Successful Resolution applicant during his submission submitted that the SRA shall be paying an amount of 113 crores to the workmen as per the resolution plan, since it was contemplated that if liquidation value is more than rupees 52 crores, the liquidation value shall be payable to the workmen. To clear any doubt, we deem it fit and proper to issue direction to the SRA to make payment to the workmen of rupees 113 crores as per the resolution plan. So this is part of the Supreme Court judgment. Various questions have been answered in this. Workmen and employees were entitled for payment of unpaid provident fund dues till the insolvency commencement date, which was statutory obligation of the corporate debtor to deposit with the EPFO. Thus, all workmen are entitled for payment of their full unpaid provident dues till the ICD after adjusting the amount of PF received by them under the plan, if any. The payment of amount of the workmen regarding salary of 24 months as well as PF, gratuity, etc. were not paid in full. In view of the provisions of Section 53(1)(b), we, having held that payment of Provident Fund has to be in full, the workmen are entitled to receive unpaid Provident Fund dues in full minus the amount which they have already received under the resolution plan towards a Provident Fund and gratuity dues. About the Provident Fund, the liquidation value of the employees have been found nil. No amount has been paid to them under the resolution plan. We, having held that employees are entitled to receive the full amount till the ICD, thus SRA is to make payment of amount of Provident Fund payable to the employees till the ICD in full. So here that nil wala concept will not be applicable. About the gratuity, with regard to payment of gratuity to workmen and employees, we are of the view that workmen and employees are entitled to gratuity payments due to them before the ICD. Any claim towards gratuity payment after the ICD is not admissible. Since a workman and employee having demerged to another company and their services were not deemed to have been terminated, thus gratuity payment under the provisions of Payment of Gratuity Act is confined only to the date of ICD, and SRA is also liable to make the said payment. It goes without saying that with regard to payment of gratuity to workmen, any amount towards gratuity paid under the plan is liable to be deducted and adjusted. Again, those who have not been terminated, their gratuity shall not become due right now. Only the amount of liabilities due till ICD shall be paid by the SRA. Secure debt. The preamble to the so any views on the rainbow judgment, whether the secure debts, the attachments or the security created by way of operation of law by the other authorities, whether they rank pari passu, whether they rank equally with the secured creditors, being the financial institutions. Any views on that?
Madam, this kind of judgment, definitely bankers will be in trouble because they don't know what is the statutory due and things. They will take things for granted unless they monitor the defaulters very carefully regarding the statutory dues. They will be caught in the wrong foot.
Yes.
Definitely, it put a extra responsibility on the banks to monitor the borrower. Otherwise,
Yeah.
they will be in trouble. This is my view. That's
My
a
personal
ex-banker.
view, madam, is
Yeah.
regarding the extinguishing of the claims of gratuity and PF. Once the resolution plan is approved, and freezing of the claims seems to be somewhat unjustified because so many people will miss it in filing their claims from the and earlier judgments. We have been told that NCLT, even after resolution plan approval, they were told to pay. Here there is some difference of opinion. What you will advise?
Let me hear from others. What do you think, bankers, financial institutions who have given loan and created security should be given preference as we have understood since inception of this code?
That is okay, but the rights of the employees and workmen are above all, because the banks and other financial creditors are the big fish, whereas the employees and workmen are the small fish. They should not be sacrificed for the sake of the big bankers and all that.
But what do you think that they are being taken care of? They are already there at par with the secured creditors, workmen's dues, employees' dues. You have seen Section 53 just now.
Yeah, yeah.
But I'm talking about the recent judgment, which is still under discussion and under review also. I'm just wanting to have views whether the local authorities or the other authorities, other uh, departments who have their claims and who have security created under other laws, whether they rank pari passu with the secured creditor or the bankers, etc., which who have their rights.
They don't rank pari passu. They will be eligible under Section 53 only.
Yes, and government dues have been given a special position under that, and
Yeah,
that is
they
the
were given
fifth
under
position.
Section 53E or something like that, on all statutory dues and government dues.
Yeah, they
They
are
cannot
given
be
fifth
elevated
rank.
to a priority position under Section 53 without any amendment to the Act. Supreme Court has held that in the Maharashtra Act, which is before the GST, I believe, introduction of GST. So they are relying on that
Under
Act.
GST also they have certain rights of attachment and creating security. Under
No,
customs
no,
also, under income tax also.
but subject to insolvency and bankruptcy code. That
Yes.
disclaimer is.
And yeah. Okay, so my view, it is only my view, what I wish to share here. Although we have seen in all the judgments that these dues need to be paid, and I totally understand and agree, and we all agree that these dues need to be paid in terms of Section 53 as well as Section 30 subsection 2. But the security created by these departments or authorities, I'm just taking that concept at present. The security created by those are whether they are the secured debts and ranking at the same ranking under Section 53 with the financial institutions, etc. My view is no, because the intent of the IBC since inception was to alter the order of priority of payment to the government dues. It is written under the preamble of the IBC itself to include alteration in the order of priority.
Yes.
Categorization of statutory dues as secured creditor would appear contrary to such objective. We definitely need a legislative intervention to settle this subject. Under Section 53(1)(e) subclause I, it is intended that statutory liabilities be paid at fifth rank and not at the same rank at the statutory creditors. An amendment is required, which is flowing from the Rainbow Judgment. Rainbow Judgment has actually brought a need. It has highlighted a need to bring a clarity on the orders of priority of distribution to the stakeholders. It can add accept statutory dues under the second level, where they are talking about the secured creditors dues, and then they can add whether secured or unsecured with the government dues at the fifth level. So it will bring a clarity that secured or unsecured government dues, whatsoever the nature is, that will rank at level 5 only, and at the second level only the secured creditors except the statutory dues shall be taken care of. So let us see where it leads to.
Madam, in this case, you mean to say that PF and gratuity dues, irrespective of the period, they have to be paid in full, as far as an essence of all these judgments. And salaries can be restricted to 24 months. Is that right?
Salary is also part of those dues only. All the dues for a period of 24 months shall only be paid,
No, but here all these judgments says even if it is provided for the resolution plan for 24 months, beyond that, if PF dues or gratuity dues are there, that has to be
No.
paid in full. That is the judgment.
In full means whatever amount has been admitted, that has to be paid by the RA. Okay.
It means naturally they will admit only to 24 months.
He will admit for 24 months only. He can admit for the entire undue period, but the RA is obliged to pay for those 24 months only.
That's okay, but whatever the content which you have shown as per the judgments, many of the judgments it was clearly saying that even if it is provided for 24 months in the plan, if it is exceeding 24 months, entire all full dues have to be
No,
paid.
sir, no. Here we have talked about difference between section 326 and 36. If you recall, they say that 326 has the entire amount due, and our 36 has only our 53, section 53 has only period limited to 12 months for employees and 24 months for the workmen. That was in one of the judgments. They have clearly demarcated, brought out many differences among these two sections.
There is a small confusion here.
No. See, while applying 53, 326 is relevant only for the limited purpose of understanding the definition of what is workman's use. Right? On the other hand, the workman's use, as mentioned in the section 326, is not confined to a period like 24 months preceding the liquidation commencement date, and therefore the appellant, for the purpose of determining the dues, cannot derive any advantage of section 326 of the Companies Act here. He has to go by section 53 only. Yeah. It has to be only used for understanding the meaning of workman's use, because that has not been defined under IBC.
So, madam, in the same line, whether any limitation is applicable for this use?
Limitation, what kind of limitation, sir?
For any claim, there is period of limitation. If it's beyond limitation period, the claim can be rejected.
There, under their respective laws,
Yeah,
there are periods of limitations.
Correct.
But under IBC, we have our own period.
No, we have our own period, and that's okay. But Limitation Act is applicable to IBC also.
Yes, but they are claiming their amounts due for previous so many months or years, but they will be paid only, the SRA shall be paying only for 12 months to the employees and 24 months to the workmen.
What I mean to say is, if any employee is claiming very old dues, in that case, can we reject under the Limitation Act?
I don't think under IBC he'll be getting those paid.
Under CRP, if resolution under SRA can provide for anything.
Yes, SRA can. SRA can provide. Yeah.
SRA can provide only if the resolution professional admits it.
Yes.
So my question is whether a due which is beyond 3 years can be rejected at the admission stage itself.
Yes.
That's what I'm asking.
I think yes can be rejected by the RP.
Because in all other cases, we are rejecting the claims which are beyond 3 years in contractual.
Yeah, but on employees, there has not been any specific precedent I have seen. I think beyond 3 years, the RP can reject their claims as well. Any other view on this? Any other questions?
Kindly share the PPT, madam. You have made a very wonderful PPT. Help us in getting this knowledge, share this knowledge to all the IPs who have participated.
But I don't see people participating here. Ankita, can we just prompt them to be more participative? You know, last time also I highlighted this to Anjali also. Somehow, you know, please don't mind. I see AI people to be more participative, and I see SI people not to be so. I had 169 slides presentation, and I finished that without discussing, without getting any query in between.
You have made a wonderful presentation. That's why I just got it.
I would like to request all the participants to please switch on their cameras, and if they have any queries or doubts, ma'am will address the queries, and we can just have a general discussion on the topic as well. If anybody wants to share their experiences with regard to this, we can do that as well.
So you mean to say that, madam, any successful resolution applicant has to keep in mind the PF dues and gratuity dues, amount of PF and gratuity dues while submitting his plan, going by this,
Definitely.
going by this Jet Airways.
Yes, and the IP should be very careful while drafting the IM. He should specifically write down the liabilities as on ICD with respect to these funds, etc., these dues of the workers as on the ICD in the IM, so that our, SRA can provide for those amounts.
The insolvency professional himself is not clear about what are the dues in the absence of claim by the PF department or respective employees. And if they come at a later date, how can we mention in the IM?
But you can definitely update the IM. You have a right to modify it from time to time. The list of liabilities can be modified and told to the SRAs.
That can be done, but see, it is a laborious process, but updating the claims.
That is what we are witnessing now. That is our problem, practical issues, that employees and PF department, etc., will start filing claims at the fag end of the CRP process, and while we are through with the plan approval, etc., and that time new amounts come up, and then the SRAs are sometimes not in a position to take up those liabilities as it is. It may not be in their financial capabilities, so entire process goes haywire.
My suggestion is all the IPS and IBPA should take a training classes to all these PF commissioners and tax authorities, so that to enlighten them on the provisions of the IPC, so that they can file the claim in time and get their
Yes.
dues and pass on to the respective employees.
Now you must have observed a lot of awareness and I should not use word education. Lot of awareness amongst them. They have also got to know. They have also got educated on the subject. Earlier, what used to happen, हमें बोला जाता था इनको छेड़ना मत. आपने जैसे इनको लेटर भेजा यहाँ से पुराने वो शुरू हो जाएंगे इनके claims. Belonging to the past period, and you will be caught in that in responding to those and fighting those cases only. But now we have seen much improvement in all the government departments also. We are seeing people who are aware. We are dealing with those people who are much aware of the subject. Earlier, electricity departments was not aware that they are coming under the essential services, etc. So gradually people are becoming aware.
IBBI is taking special training sessions to these bankers.
Bankers, yes.
COC,
Most important.
COC members.
Yeah.
So in the same way, they can guide the PF and other tax authorities.
They must have sent clarifications. They must have sent circulars to them. But you are aware who reads over there.
No,
and
no.
Who is
For COC, they are conducting physical classes.
Yeah, I know. I have also taken one.
Yeah, in the same way, they can take to other government departments. That's what I mean.
COC is the first hand. COC, PF department, etc., may not be relevant for all the IPs, but COC has to be aware. Their conduct had to be, brought under one proper format. But COC के बिना तो काम ही नहीं चल सकता ना.
At least lot of problems of RPs get solved if proactive action is taken from IBBA.
Yeah, but a lot of IPs have made them understand also. They have understood by way of, legal battles fought, and they have not succeeded over there. And generally also IPs keep explaining to them, keep writing to them. तो उससे समझ में तो आने लग गया है सर, ऐसी बात नहीं है. काफी फर्क पड़ा है अब तो. Anyone else having any experiences to share?
You have very nicely enlightened us on the labor laws and employees and workmen issues, which was always taking the back seat. But now it is also, we have learned it is an important matter and not to be ignored.
Yes, because later on the hassles will come, and definitely being a social welfare state, being a social welfare country, we will definitely take cognizance of their liabilities. We'll allow them to, file claims, etc. And we will direct the SRA to bring extra money. So we can be cautious, a little more cautious since inception itself, and take
More
care of
so,
those liabilities. Yeah.
more so because of the financial creditors and secured creditors, because of their bigger issues, our
Yeah.
total focus and attention was going to them, and
Yeah.
this aspect was going to our lesser attention.
Yes. One needs to explain to the employees and workmen who are, क्या होता है उनको promoter बोल देते हैं देखो ये आरपी आ गया ना इससे ले लो जाके अब ये देगा तुम्हारी पुरानी सैलरी तो one needs to explain to them very clearly that what is their due and up to what period they are entitled to claim and what will be paid to them and what cannot be assured. So these things if told to them in advance and if calculations are made in advance, so this that will save lives of not only the employees workmen but also the आरपी का भी तो आगे पीछे दिन रात employees लगे रहते हैं ना, old employees old dues वो चलता रहता है, and you know have to sometimes ignore them for larger subjects, larger issues.
Right.
One clarification I just remembering, while submitting the claims by these employees, in recent times you must be aware that this concept of CTC is there for all the employees, private sector especially. In the CTC, there are several components, and one of the components is variable pay. See, all these employees, they, if any past, while submitting the claims, they include the variable pay also as part of their claim, which is a subjective in nature. How to deal with those situations, because the variable pay is normally performance linked, except in some cases where they may they do it every year, they will pay this variable pay just like bonus. But it is not the case with many of the countries. It is a subjective nature linked to some performance.
See, my view is in that case, you need to take extra evidence from them, more proof regarding with what their performance was linked, with what their variable pay is linked to, and you need to, verify your claim with some external source also, not only based on the documents furnished by them alone.
It is based on some appraisal, and that appraisal itself has not taken. Whether RP can do an appraisal for an employee,
No, I don't think appraisal is a part of our normal duty to carry on the business. One needs to, ensure supplies of raw material, supply of right kind of people and the funds. I don't think appraisal forms part of our ordinary course of business. But yes, if everything is going good, the company is going good. It's been 3 years. You may
I
go
have
for
seen
an appraisal
companies.
and set a precedent for all of us.
No, I have seen companies where these increments were given during CRP.
So,
Okay.
ma'am, there is this company where I was the RP. It had 900 employees and it was an IT company.
Mm-hmm.
And it was completely employee dependent.
Okay.
Now, the company, obviously, it became an NPA, etc., for whatever reasons, but it still had bank balance. It had sufficient bank balance. Now, the employees were very clear, that if they are like this gentleman just pointed out about their variable pay and all, it was very much part of their appointment letters. If they won't get that variable pay and, if we basically, deviate from the regular norms of, doing performance analysis of employees, I mean, these guys would easily get job and the whole company would come down. So while it was not really an RP's job to do a performance analysis of employee, but there were HR systems in place when I took it over. So we just continued with the HR system and whatever the HR would then recommend. I mean, we would go and then we would generally call the meeting of the promoters, directors. I mean, while they may not have powers, etc., but you would try to run the organization as if it is not in CIRP. Like just
Yeah.
it as a
That
goal.
is the success. That is the success.
That is the success. Yeah.
So there are two aspects here, Krishna ji. The one which Mr. Srinivasa has pointed out relates to the prior period. And while filing the claims, if they insist that there was a variable pay also attached to it and he's not able to verify that, so he might get into deep, dig out more documents, or get in touch with the HR people, or records available, of course, whatever is available. But for the going concern, for the CIRP period, if the company business is going on, and ordinarily, if you have to make a performance analysis for making payments of their regular salaries, which also has a variable component, then definitely you will need those HR services in case employees, the nature of job is such. Definitely. And appraisal is a nice concept I've come to know today. That is
Actually,
good.
this is essential, or I would say part and parcel of the going concern. Without that, actually, you cannot run the CIRP. In most of the cases, CIRP is running beyond normal timelines.
Yeah.
So if it is a period of 6 months or 9 months, we can just afford to not to appraise their salaries or whatever. But if the CIRP is running into years, 2 years or 3 years, then we have
Yes.
no choice.
Yes.
And coincidentally or intentionally, legislature has not mentioned these sort of activities in section 28, where we are supposed to take a special approval from the COC.
Yes. If the company is normally going on, business is ordinarily going on, and it is going concern, the sufficient revenues are being made as in the past, or maybe better than them. Definitely, RP can, being in the position of a CEO, he can announce appraisals also, carry out the appraisals in the proper manner, whichever is applicable to the company via HR maybe, and then announce increments.
The only thing which I personally feel that the increment should be in a reasonable proportion. It should not be like 30%, 40%.
Definitely, there are people IPs के लिए तो बैठे रहते हैं ना हमेशा. आपका तो हमारे तो regulators बैठे हैं. Within the employees only our complaints will be filed, you know.
Yes.
It may lead to complaints against
IP, definitely.
My name is BK Mishra, Vijay Kumar Mishra. I share my views that in those cases, I think first thing which RP should do during CIRP to review the entire salary and wages structure and the criticality of the position of an employee. There are some employees who are critical, which may be needed more during the company during CIP than in an ordinary course of business, and there are some scope where the employees may not be that much, because considering the profitability concept, this appraisal, performance appraisal, is a subject which should be came into picture when performance of company is going on well and it is transforming into profits. Otherwise, basics, if company is not earning the profits during CIRP, but earning profit, okay, you can increase salary, anything you can do because you are maximizing the wealth. But in case company is not earning the profit because case is admitted, so one has to visualize whether this is the profit is going on or not. Going on concept is one thing. So in that case, I think variables and other things, only if targets are achieved, then can be given. Otherwise, one should take this cause of the profitability and whether company is earning or not earning. But my experience is that during CIRP, companies' profitability is only you can contribute. Profitability is not that much good. So this performance appraisal, and it is a matter of only when company is doing well and earning profit. Because during CIRP, some of the big companies where the case is admitted due to any accidental way or otherwise.
No, I am not able to understand the role of IP as far as appraisals is concerned, because already we are dealing with a sick company.
Exactly. That is my point.
How can we enter into appraisal?
That is what I'm saying. In case you have profits and in case it is important, like Mr. Mishra rightly pointed out, that some employees are critical. Like Mr. Krishna told that they will not work for the company in case those variable pays or performance linked incomes are not provided to them. Then it becomes important for you to carry on the systems of appraisal as well. But everything is a game of money. Ultimately, you have funds at your disposal, and you have they are contributing to the profitability. You are able to justify your steps, your decisions later on.
Because you have to justify your action before COC.
Definitely.
Actually, we have to understand that on one side, we are not in position to make the payment of their salary before pre-CIRP period. On one side, we are just pushing them hard, because CIRP in itself a very we cannot take it in a positive sense. No doubt it is already running into for us as a professional. So every year we are having inflation about 7%, 8%, 10%, and other side you are not giving them a reasonable hike, then definitely they will leave the organization and you will come into the trouble.
The first thing I think yardstick is whether you have to see first whether your turnover and volume is going up or going down. If it
Yes.
is going up, and profitability, two concepts. If it is going up, you can justify your action for increasing the pay. If it is not going down, then certainly, if any employee goes and which is not critical, let him go, as per my perception. Because your everything turnover and going reduce. It is better that if employee used to opt to go, that is in the interest of
Yes.
company, because you will need not to pay him the salary more. So, and
Yes.
as on date, I did not see any company which is admitted in CIRP where turnover has been doubled or tripled, so that you
Yeah.
have to pay variable pay, etc. So I did not find it. There may be a company, but during CIRP, yes, if it is going, company volume is increasing, profit is increasing, it is not reducing, you have to stop the employee from going out. And otherwise, it is a blessing in disguise during CIRP if some of the employee opt to go, because I have one case where company was going on and subsequently it came to liquidation and one case has been resolved. So some of the employees, which like unionized employees who don't work, if they used to go, then it is better for the company to go, because you have to take a new blood. Once in case this SRA will come, he will certainly have to seek take new pupils.
Yes.
Except some of the critical, as I told, which are important for historical point of view, from the record point of view, keeping the old data with you, that is important.
Sir, it all depends on case-to-case basis.
Exactly,
Yes.
exactly.
Exactly.
But sir, my point is, I have not seen
Generally,
any
yeah.
company,
No,
any
that's
company.
why I just wanted to give an example. I know a power company which is
Yes.
based out of Hyderabad, which is into CRP since 2019, and
Okay.
it is still yet to be resolved. Okay,
Well,
and
so here, sir, we have to see
please,
whether turnover, etc., are increasing or not. What is the status?
please listen to me. It is not
Yes,
related
please.
to
Yes,
turnover.
yes, yes.
It is a power generation company, and they are getting revenues every month. All the units are operational.
Yes.
And lenders are not getting paid because of CRP, because all the amounts which are coming are pooled and only operational expenses are being met, like salaries and all. Lenders are not being paid. Okay, it is almost 4 to 5 years. All the employees are agitated that they were getting, there are no claims of employees for the previous dues because the company was paying, except lenders, they are paying it to everybody. Okay. So there are no previous dues. They were getting increments before that once in 2 years or 3 years. But the company went into CRP. It was admitted. It is almost more than 4 years. So these people were agitated. So the RPA was forced to give an increment and he has given it, taking the COC into confidence. Even though the company is not profitable, but it is running all the units and generating income, and all the income, it amounts to around 1,000 crores of amount was kept in fixed deposits. All the
No
revenue.
issue. Certainly they should give. No issue. Very well.
It is not a profit-making company because they are not paying to the lenders. It is not. It is.
Sir, excuse, sir, another thing we keep talking about.
Sir, profit is not the only concern. It is the contribution. If they are maximizing the value, if a plant is not stuck down, so that's why we are increasing the salary, then it is very fair enough.
Mishraji, the thing is, we keep saying COC. My experience has been, I've done almost 6-7 cases now. COC says very simple thing. If you have money, you please do it and follow IBBI norms. Don't come and ask from us. So everything is true. The minute you go to COC asking for money, then they will ask questions. It is
no, so I think we have got the answer from Asap's point that company is operating and money is there, cash is there. That's why if you have to increase, operations are going on. Certainly, it is fair enough to increase the salary because you are anyway giving some contribution to the company. Maybe profit or may not be profit. Operational cost is being met. And because plant is running in that way, it is a power company. Certainly, in case it will be stuck down, then total value will be reduced than the whatever today we are getting. So that is depend case to case, no issue. But in more of the cases, it is not feasible for an RP to increase the salary. Otherwise, wherever there, in this case, what I found that this CIRP admission is accidental because company is not in losses. If it would be in losses or it is not growing on, that is my point.
Okay. Anything else? Any other question we need to deal with?
I think we can conclude, madam.
Yes, Ankita, shall we close?
Yes, ma'am. Ma'am, we'll close the session. If anyone has any other doubts, any other discussions that they want to take forward, we can take it right now. Otherwise, we'll conclude the session. If there are no more questions, then I would firstly like to thank ma'am for taking out time and explaining the topic in depth to us. Also, addressing so many doubts, addressing so many queries, and making sure that everybody was clear in their concepts. And for initiating such a lively discussion, which is, as you said, is not what normally happens in workshops. And I would also like to extend my thanks to all the participants who joined, who participated, who were active during the discussion, during the workshop. So thank you very much for joining in. And thank you very much, ma'am, for taking the session. We'll surely like to call you again and have another session on some other topic whenever.
Definitely. Thank you so much. And thanks for the participation. Thoda so ke uthe sab log.
Thank you.
Thank you. All right.
Thank you, everybody. Thank you.
Ankita, can you share the PPT of madam?
I will.
I'll share the PPT. I'll share the PPT. Once ma'am shares it with me, I'll send it to everybody.
Okay. Thank you.
Thank you. All right.
Thank you.
Thank you.